Thank you so much for joining. I'm Lisa Smith, Senior Research Fellow in Business Human Rights at BICL and Director of the BICL Human Rights Due Diligence Forum. Thank you for joining us today. This is the first session of a two-day conference running today and tomorrow on the topic of human rights due diligence and systemic inequalities, with 2 sessions each day. All 4 sessions will use the same link, so please do join us for as much or as little of it as you would like. And the recordings should also be available on our website in due course. We have closed captioning enabled, so please click on the live transcription to see this. I would also like to thank my colleagues at BICL, particularly Liam and Carmel in our events team, for their patience and preparations, and also for all the other colleagues who were instrumental in the conceptualization of this conference. I'd also like to thank Sorka McLeod, our co-organizer at the University of Copenhagen, who I will hand over to in a few minutes to say a few words of introduction as well. And I would also like to thank our excellent speakers for being willing to share their time and insights with us over the course of today and tomorrow. It really is a brilliant lineup, and we are very grateful. Lastly, to everyone joining us in the audience from many corners of the world, thank you and welcome. We hope this will be a fruitful discussion. Equality is central to the origins and conceptualization of human rights, and therefore, in order to identify and assess the actual or potential adverse human rights impacts of a company, its human rights due diligence by definition needs to take into account the inequalities that are embedded in the systems where it does business. And yet, human rights due diligence is frequently not explicitly framed using the language of intersectional systemic inequalities. Today and tomorrow, we will hear examples of how this could and should be done, both conceptually and practically, and what we can learn from the past and present on how to take this forward into the future. Also, these questions do not only relate to Pillar 2 of the UN Guiding Principles and the corporate responsibility to respect human rights, but very importantly, they have implications for Pillar 1 on the state duty to protect human rights and Pillar 3 on access to remedy, especially as we are now entering an era with a new wave of regulatory developments that seek to turn human rights due diligence into a legal duty of care. And this is a field in which BICL has recently undertaken research, and please do have a look at our business human rights page for some of our recent studies. As we know, Germany has recently introduced a new supply chain due diligence law, and there is currently legislative initiative underway at European Commission level to introduce mandatory human rights and environmental due diligence as a legal duty of care. Multiple other campaigns and legislative proposals are underway across the European continent in particular. It is concerning that there seems to be a debate about whether it is an option to leave out the right to remedy from these new statutory instruments, but instead to frame these laws towards the most convenient exercise of administrative oversight in the global north on behalf of rights holders, rather than at their behest and through their own agency. When rights holders are expected to be witnesses or whistleblowers rather than plaintiffs in matters that concern a violation of their own human rights, when they are to be shepherded through this process rather than conducting it, and where it culminates in the consequences for the company but no remedy for those affected, the regulatory relationship takes place exclusively between global north oversight bodies and companies, and this removes the centrality and the equality and the dignity of the rights holders from the equation. Moreover, the statutory model redirects victims to the existing tort law system for their attempts at obtaining remedy, and we have seen that these frameworks pose several barriers, particularly in transnational harms claims. So the effect of foregoing the introduction of statutory remedies is that European-based victims would often have access to remedies that victims in the global south would not have access to, even for the same kind of claims against the same kind of company, thereby embedding the intersectional inequalities even further into the formal legal framework. This all shows us that these inequalities are so inherently built into the systems that they are even embedded in the ongoing regulatory movements that seek to address corporate human rights harms globally. So from this, we can see that today and tomorrow's discussions are not merely academic, but urgent and central to the work that we all do at the moment. I will now hand over to Sorka McLeod, our co-organizer, to say a few words of introduction, after which she will hand over to Freya Dinshaw, who will be chairing this morning's panel. And thank you so much again to all.
Thank you, Lisa, and welcome everyone. I see that the attendee list is well over 100 now, which is fantastic. And I think that really just illustrates the first point that I was going to make about how entirely timely this event is. When Lisa and I were reaching out to potential speakers to participate, there was an almost uniform response, which is yes, fantastic. fantastic. This is a really super topic, and it's one that we should be focusing on. And we really did not have to work hard to convince people to join us over the next 2 days, which I think says something about the currency and timeliness of the topic. We do, as Lisa said, have an amazing lineup of speakers, and we're extremely grateful to welcome everybody. And I hope that as many of you are able to join us for the four sessions, no matter where you are in the world. I'm particularly happy to welcome everybody on behalf of the Centre for Private Governance at the University of Copenhagen, which is co-organising, co-hosting this event. And I'm especially delighted in my own personal way to be co-organiser, as I am a new trustee of BICL, and so I have a particular connection to the organisation, and I think it does a really fantastic work in the business and human rights area. I think the third point I would like to make is that, given that we are seeing the binding treaty process moving forward, hopefully, yet again, I think there are opportunities for us here to feed into that process, to get the issues around systemic inequalities included in that process. But I also think we have to bear in mind that there are other significant mechanisms within the business and human rights sphere that have a lot to add to the discussions and debates about business and human rights generally, but specifically about systemic inequalities. And I think we'll be hearing about some of those mechanisms. In fact, I know we'll be hearing about some of those mechanisms over the next couple of days. So without further ado, I would like to hand over to Freya Dinshaw, who's a senior lawyer at the Human Rights Law Centre in Australia, and to thank her and to other colleagues who are joining us at somewhat anti-social hours for this conference. And I know I speak for Lisa and myself that we are extremely excited about the next 2 days. So over to you, Freya.
Thank you so much, Sorka and Lisa, and congratulations to all those involved for putting together such a thought-provoking program over the next couple of days, focusing on this important topic. Given the topic of today's opening session, it's only right that I start by acknowledging that I'm joining you all today from the traditional lands of the Bunurong people of the Kulin Nation, and I pay my respects to elders past and present, recognising that the land that I'm working and living on is stolen land and that sovereignty was never ceded. The issue of systemic inequality is as pressing here as it is in Australia, where I'm based, as it is everywhere. And I'm certainly really looking forward to hearing various perspectives and discussing the interplay between the field of business and human rights and systemic inequalities with our wonderful panelists today. So first, I'd like to introduce you to our distinguished speakers for this morning's session. And if you would like to find out more about our speakers, there will be a link available in the chat for you to read the full bios for everybody. So we have Krishnendu Mukherjee, barrister from Doherty Street Chambers in London. Manel Chibane, who works with the Docket Initiative at the Clooney Foundation for Justice, who is a French-Algerian lawyer qualified in France. Professor Michael Addo, Professor of Law at the University of Notre Law School. Rachel Davis, co-founder and vice president of Shift, and Professor Benita Meyersfeld, a human rights lawyer, academic and advocate from Wits Law School in Johannesburg. In terms of our housekeeping for this morning's session, if you've got questions, we encourage you to use the Q&A function through Zoom, and please post your questions throughout the presentations today as these come to mind. Noting that there may not be enough time to answer all questions at the end, but our speakers may be able to respond in writing where this is possible. So we're going to get started straight in now. And first, we're going to start with the conceptual questions around what is systemic inequality and what do we mean when we talk about structural inequalities, and how does this tie in with business and the UN Guiding Principles on Business and Human Rights? Krishnendu, you are an English barrister and Indian advocate with over a decade's experience in legal practice around human rights and environmental violations. Could you say something about the interrelated and systemic nature of systemic inequalities and how one violation frequently leads to another?
Yes, thank you, Freya, and thank you, Bickle and the organisers for the invitation, and just like to express my pleasure at being part of such a illustrious and knowledgeable panel. I mean, I just wanted to give some of the insights that I have from my work in the subcontinent, in India and Bangladesh, in relation to human rights due diligence. Obviously, in relation to Pillar 2 and its core concept of human rights due diligence, in my view, it's not simply enough to look at the supply chains upward or downward, but to look at the cause and effect of those violations. So for instance, if you as a business entity identify forced labor in a factory or in a mine, it may have multiple causes and effects. So for instance, the migration to that factory might be caused by environmental issues, more increasingly things like climate change, or it might be caused by land acquisition where proper compensation hasn't been paid or hasn't been speedily paid. That forced labor, that labor that's being paid below the minimum wage, may lead to debt. It may lead to other violations which flow from debt, such as sex trafficking and child marriage. And so all these things need to be seen when you're looking at, when you're doing your human rights due diligence in order to get the full account of the violations. And it's not hypothetical, because in a couple of surveys that we've done, for instance, in the Rajasthan sandstone industry, and more recently in relation to a climate change project in the Indian Sundarbans, which is an area where there's been a large number of climate refugees, we've found that this is exactly what's happening. People are forced, because of lack of livelihood issues, into forced labor in garment factories, in mines, in other places, and because of the wages being so low, and when they're, because of, let's say, COVID, being forced back to their home areas, they get into this debt cycle, which causes all of these issues, and issues like child marriage and sex trafficking have increased because of these reasons. And we're going to talk more about this at the launch of the Sundarbans project on the 1st of November, where details can be found on the King's College and Doughty Street Chambers websites.
Thanks so much, Krishnendu. And we also, just to follow on from that, could you elaborate on how basic inequalities could lead to a situation where people often can't escape the many violations that they face, and how this wider context could be addressed?
I think a lot has been said about the difficulties in assessing human rights violations because of the opaque nature and because of the diffuse nature of many of the violations. But from my experience, the reality is that many of these violations are actually very much apparent, and it doesn't take much, or shouldn't take much, human rights due diligence to actually discover them. So for instance, in one of the areas that I've been working in, the Rajasthan natural stone industry, here you've got 33,000 natural stone mines, sandstone mines mostly. You've got over 3 million mine workers. You've got nearly 400,000 child laborers. You've got very high levels of occupational disease and very high levels of sexual harassment. And it's an industry where there is a British and EU connection in terms of the importation of that stone. And it's always, and these things are always put that, you know, it's very difficult to find out the violations. But the reality is, in an industry like that, and that's replicated in many industries, there's such a wholesale lack of compliance that it should be easy to find out what the violations are and put in place some degree of remedial measures in order to try and address that. Similarly, in another industry that I've been working in, the asbestos industry. There are also EU suppliers to that, and I've done a blog which is available. I think a link may be put up about it, which looks at the connection between EU companies and the asbestos industries. We all know that the asbestos industry is something that is well known to be violated for many decades and now, and yet there is still EU business activity within that sector in a country like India. And the tragedy that I have is just despite working in this industry and trying to educate people about the risks of asbestos, people continue to work in that industry, and the reason is because of the fact that there simply is no viable alternative. You know, those are the better jobs, and so even though they know the risks, ultimately they remain in these risky occupations. How do we solve that problem? I think there really is, and we were talking about EU laws. There really is a necessity for companies based in the EU now to use their economic leverage to improve the conditions. The obviously violative industries in which people work in, like the asbestos, but certainly improve the conditions so people aren't forced to work in poorly paid or unstable jobs like many in the global south that I come across.
Thank you. We're now going to turn specifically to the UN Guiding Principles on Business and Human Rights and talk a little bit about how systemic inequalities fit within the UNGP's framework. So Manel, this question's for you, and you've written on a structural reading of the UNGPs in the context of systemic inequality. Could you elaborate a little bit on this for us?
Sure, thank you, Freya, and thank you very much for the invitation to participate to this first panel. So I will give a bit of a background first. I wrote an article on systemic inequalities and the UNGPs following the renewed focus on the Black Lives Matter movement in 2020, during which numerous businesses publicly expressed solidarity with the movement with no oversight mechanism to see whether they were actually committed to fighting systemic inequality. And so during my research, I noted that, interestingly, one of the first business and human rights frameworks sought to address those structural inequalities, and that framework is the Sullivan Principles, introduced by African-American Reverend Leon Sullivan in 1977. And he was a board member of General Motors and urged US businesses operating in apartheid South Africa to increase, I quote, the number of Blacks and other non-whites in management and supervisory positions. And so in 1999, then UN Secretary General Kofi Annan relaunched these principles into the Global Sullivan Principles on Social Responsibilities. And under these principles, the focus is very much on the structure of businesses, as they ought to encourage, I quote, racial and gender diversity on decision-making committees and boards. So now, when one looks at the UNGPs, they do not quite adopt that structural approach, but rather focus on the impact of businesses in the conduct of their activities. So Lise, you have presented the UNGPs in introduction. I will just add, for those who are not familiar, that those principles apply to all states and all business enterprise. So transnational, other enterprises, regardless of their size, sector, location, ownership, and structure. And so the UNGP established this shared human rights responsibility scheme organized into 3 parts that follow the protect, respect, and remedy framework developed by late Professor Regain 2008. And essentially, they provide that states must protect human rights and companies should respect human rights. And an interesting feature of the respect principle for businesses is that they can conduct due diligence procedures and track the effectiveness of their response, paying particular attention to the principle 20 says marginalized and vulnerable groups. And the Human Rights Council elaborates that those groups include women, minorities, migrants, persons with disabilities, or indigenous people. So the Human Rights Council mentioned those groups face increased risks of negative impact from business activities. And they actually gave an example, which is that businesses should avoid racial discrimination by a restaurant. A typical example, sorry, of human rights abuse would be racial discrimination by restaurants in the treatment of their customers. But here, we still see that it's not about addressing systemic inequalities. And that's where a structural reading of the UNGPs is more likely to address those structural inequalities, and would consist in making the structure of corporate entities as a component of human rights compliance. So that would allow for more scrutiny into the composition and structure of businesses beyond the requirements of corporate law. And so if we want to be more on the conceptual side, it also allows to fill what I can call the equality gap, which is that despite the two international covenants that provide for non-discrimination and gender equality as overarching principles, systemic inequality is rarely approached through a human rights lens. And that was very much illustrated by the Business and Human Rights Research Center that recently noted that 83% of business executives consider human rights a matter for business, while only 5% consider inequality as a key area of concern. So here we see that there is really a gap to fill. And to me, the structural reading of the UNGPs allows to kind of place the inequality debate within that human rights space. And it constitutes an opportunity to address systemic inequalities.
Thanks so much, Manel. Professor Michael Addo, could you speak to us now a little bit about the conceptual perspective of the UNGPs to the idea of systemic inequalities, and explore the adequacy, or in fact inadequacy, of the UNGPs framework to the idea of systemic inequalities?
Right. Well, thank you very much, Freya, and thank you, Lisa, and everyone for the very kind invitation. It's very nice to see very old friends gathering here. Freya, in the spirit of the tribute that you paid to the indigenous people on whose land you are currently working, if you allow me, I'd like to pay tribute. And because this is the first time I'm appearing in a public kind of forum since the very sad and unexpected demise of Professor Raggi, and I really should kind of register that pretty much this conversation and pretty much all of this conversation revolves around that person. Now, I realize that Rachel is on here. I don't mean to kind of stir your pain, but I really want to pay tribute to you, Caroline Rees, Lena Ventland, Gerald Pashu. If I could only list all the people in that team who have made this kind of conversation possible. And if it is ever possible, just like you've done in Freya, I would like to hope that any conversation in the UNGPs should have that tribute as a precursor. Anyway, so I thought I should do that. I knew this was unscripted, but I just couldn't do it without having to acknowledge John Raggi. The other thing that I really want to touch on Krishnendu and Manel's point about the nature of systemic inequality. And what I gather, of course, is that it's both of a micro nature, such as the example about discrimination at work, and a very macro nature, so the examples that Krishnendu described in supply chains, but also even bigger is the whole international economic system has structural inequalities, the international trade system, the international finance system. Pretty much what we are sitting on is the nature of the systemic inequality. So it gives us a much bigger problem, which we really must address. So it tells us also that none of this was a product of the UNGPs. Everything seems to predate the UNGPs. Well, if that is the case, then the UNGPs essentially respond, or at least should be seen as responding to these inequalities that predated. Otherwise, it's not good enough. And I think it does so very well. And it does so not particularly with a focus on responding to the effects so much of the systemic inequality, but rather trying to figure out some of the root causes of some of those systemic inequalities. Now, I'm sure that we can imagine a whole variety of root causes, issues of power imbalance, which I'm sure will come up, issues of greed, issues of intolerance. But actually, one particular, and the UNGPs tries in many ways to respond to all of this. But the one particular one that I found very fascinating as its main value added is to try and reconcile tensions and conflicts in social values. So, and I'm not suggesting the other bits are not important, but this, it seems to me, is the added value in thinking that, well, we cannot deny that we have created a social consciousness that suggests that a certain economic approach to the conduct of life is acceptable. Now, I'm not disputing that. That is the platform where we are all starting. And so the UNGPs recognize that this is, but it does so sometimes with the excessive isolation from an equally important value, which is the rights of individuals. Now, there you have the tension, and there we need to reconcile. And I think that is the conceptual basis in which the UNGPs acknowledges that the economic approach is something that we have, as a society, have taken. It's not taking any kind of positions as to whether it's right or wrong, but this is what it is. And this is we also value the respect for human rights, but unfortunately, we don't have a way to reconcile. And so it tries in its processes to try to reconcile it. And it tries by doing so with the principles that underlie the UNGP's principles of shared responsibility, the principle of due diligence, principle of smart makes, access to remedy. All of these is finding ways of bringing the various tensions together. So then you ask me the question to say something about whether this is adequate. Of course it is adequate. I think it is very adequate. But if you have to look at adequacy in a slightly different way, because the UNGP looks both forwards and looks backwards. It looks as much in terms of preparing you for a revised consciousness in terms of how you handle your economic affairs, as well as having to confront problems that we have now. Unfortunately, that aspect of the UNGP that's prospective, the one that looks forward, trying to educate people into a new type of consciousness, seems to have taken over. So we so easily think, oh, because it takes this kind of prospective approach, it's not adequate. But I just will kind of invite people to look back a little bit more on the bits that can be done right away as a way of responding to it. So you'll find that people will tell you the UNGPs are not adequate because they want answers to the problems yesterday, now. Whereas if you think about it, it took generations to get to the kind of difficulties we have, and we don't have the patience to kind of let this new common understanding evolve. But if you were to perceive it in that way, then you could actually begin to see the process as growing a new way of conducting economic affairs. One more thing to say, it's a process of recalibration, re-education, and re-understanding of how we conduct economic affairs, as well as dealing with problems that we have now. So I'm just thinking conceptually, this is where the UNGPs actually sit at the moment. Now, I should say, nobody should test me as to whether it is the perfect final solution. No, I don't think, even John Ruggie were here, he would tell you, no, this is a new strategy that actually helps us move forward. It is not an end in itself. It is a means to an end.
Thanks, Michael. And in your view, is there room to use the UNGPs to address these systemic inequalities? And specifically, what are your thoughts on how the relationship between remedy and inequalities and the power imbalances resulting from those systemic inequalities? Is there a way to build on the UNGP's framework and go forward from here?
Well, you're pushing at an open door, yes. And from what I've said so far, I can't say otherwise. Starting from the point of view that we need to take the UNGPs as the starting point, as the floor, and not an end in itself, that they are what I call a set of first order principles. They're kind of very general principles, but they're kind of general principles that are meant to be adapted and adjusted to particular circumstances. Now, this is essentially what is already happening, because if you look at some of the work of the UN Working Group, they have this unpacking project, which is what Manel was talking about in terms of reinterpreting it in the structural reading of the UNGP. You don't take it so literally. And of course, if it solves your problem literally, use it. But you need to take it in a kind of a structural way to try and use it to respond to. Now, when you do that, you begin to realize that it has plenty of mileage. Now, I recently wrote a piece of paper for the Notre journal on the elastic interpretation of the UNGPs, because that's one way of bringing the UNGPs alive into practice. Now, on the very specific question of remedy, now this is exactly the point where the UNGPs acknowledges that there are effects now that need to be developed. Remember the point about looking forward as well as looking back. The UNGPs do not deny the existence of problems now. The UNGPs makes clear proposals which are to be used for responding to. Now, remedy, on the other hand, we're so comfortable with what I call the authoritative approach to remedy. We have governments pass legislation or, a particularly kind of compelling process, which is great, which if, we can hurry up enough to get some of those, it will work. But actually, at the same time, if you're very faithful to the approach of re-consciousness, re-educating, reconciliation, well, then everybody's got to play their part. So requiring companies themselves to reinvent ways of providing remedy perfectly sits in that kind of conceptual framework, so that we don't expect that they always have to be decreed from the top. But if you understand that the economic structure needs to recalibrate, well, then you do it yourself. So I can see the sense in which remedy sits perfectly within this process of trying to get actors to share responsibility for human rights adverse impacts.
Thanks so much, Michael. Turning to Benita. Benita, you work frequently on structural poverty and structural discrimination based on sex and gender. And you've previously said that in terms of linking this to the UNGP's framework, it is for you less about the creation of remedies accessible, but about the deconstruction of those systems. In particular, that there is no incentive for a corporation to participate in the deconstruction of poverty. Could you elaborate a little bit on this?
Thanks very much, Freya. Thanks to Bicol, Saoirse, Lisa, and for having me and us, and to echo Michael's points about wonderful to be seeing so many friendly faces again. Inequality is a term that by necessity includes poverty. A person who has wealth does not claim the grief of inequality. A person who has power does not claim the grief of inequality. And that inextricable link between the social concept of inequality and the economic concept of poverty is something that I think requires redress and address. I'm not sure it's the job of the guiding principles to do that, right? I think the guiding principles are a set of mechanisms that facilitate it. I think it's the job of those with power to begin listening to those from whom they've taken power. And very much echoing what Lisa said about the development of remedies and approaches to remedies that are created by those who really have never had to use them. So I think the point of departure for me is that those fault lines and they are intersectional fault lines of inequality, are based on essentially economic power. And that economic power is exacerbated. And the reason why I say I think that corporations and multinational corporations do not have an incentive to interrupt cycles of power is because the attainment of power rests on the assurance that nobody will take it away from you. And the cycle of poverty and the entrenchment of poverty means that there is a broad workforce, and that workforce will provide and contribute to the production and the creation of all of the components that constitute the economy, right, and the marketplace. But that production, which is seminal to the workings of the marketplace, and that production, which is a precondition to the accumulation of wealth, and therefore is of pivotal importance, that production has very little monetary value. And so we see it expressly in the mining context, right, or in large-scale infrastructure development, where the people who earn the least are the ones who generally take the highest risks. The rock drill operator underground is certainly in the extraction of certain materials, particularly platinum, for example. You're never going to mechanize that completely, but that rock drill operator is indispensable to the production of platinum. Yet that rock drill operator, and there are not many of them, and it's a specialized skill, that rock drill operator is paid a salary that is an infinitesimal amount of the salary paid to the managers and owners and financiers involved in a mining operation. Now, if that project, and if the contribution to that project rather by that rock drill operator is so indispensable, we have to ask, why is there such a huge differential in the value and the payment of that work? And the answer, at least that I posit, is because of the color of rock drill operators and the original demarcation of the value of labor based on the value of the person who is doing it, which is why we continue to see women underpaid in the same jobs for the same purpose, doing the same work as men. About a 20% pay gap for the same work with the same qualifications exists worldwide. The only explanation for that is the structural inequality. So I think that the recalibration of work and the value of work and who does that work is a fundamental part of our answer. The problem, though, is there is no incentive for those with the power to address it to really do it.
Thanks, Benita. I'm now going to turn to you, Rachel. Rachel, your work includes engaging with businesses about their responsibility to respect rights and using the UN guiding principles to push the envelope of what's expected beyond their existing comfort zones. Could you speak to us a bit about how you see the potential of the UNGPs and human rights due diligence in addressing systemic inequalities?
Thanks very much, Freya, and thanks very much to the co-organisers for the invitation to be here. Like you, Freya, I'd also like to acknowledge the traditional owners of the land that I'm speaking to you from, which is the Arakwal people of the Bundjalung Nation, and to recognise that sovereignty was never ceded. And thank you, Michael, before I dive in, for your really kind and really graceful comments. Indeed, we lost an icon and a very dear friend in John Ruggie, but his extremely deep and real commitment to human rights and to the humanity in human rights, to real outcomes for people is very much in this discussion today. So I'm particularly pleased to be part of it for that reason. I guess I'd like to start by referencing what I consider the harm of calling the guiding principles a do no harm standard. I often hear that phrase, and it implies, you know, avoiding making things worse. It makes it sound very passive. It certainly has no connotations of the past or things that are being carried forward, as Michael said. And actually, if you look at the guiding principles the way I look at them, the way we look at them at Shift, getting business to refocus on risks to people is an enormous change if you think about the full potential of that change. It's the hardest thing for a company to do. It's not wired naturally to do that. It's wired to go where you have control, look at your own operations, you know, and keep things manageable. Whereas the guiding principles expect companies to go to both ends of the value chain, Look at where the most severe risks are. Go beyond contracts. Use all available forms of creative leverage. Don't cut relationships with risky partners to, to manage the PR situation. Invest proper time and resources in better outcomes. Hold yourself accountable to those outcomes. Ask hard questions about your business model. Look at who you lobby. Bring the perspectives of people who are impacted into the boardroom, into your decision making. Show empathic leadership. I mean, this is really, really different behavior. And it's what my colleague at Shift, Francis West, has called the inherent, if perhaps quiet, radicalism of the guiding principles. And I think we often see that due diligence is too often reduced, first of all, just to risk assessment, right? Just to the first part, but to risk assessment in the form of social audit with corrective action plans, for example, in a factory workplace context or on a plantation site, and with all the failings that come with that. Whereas effective due diligence requires root cause analysis. That's a very different type of inquiry. It's, I mean, scientifically, methodologically, a different type of inquiry. And when you carry that out, as soon as you do, you often quickly find a connection to systemic problems like structural discrimination embedded in institutions and social practice. And this requires serious, long-term collaborative efforts to address. And even then you still may struggle, as Bonita has been laying out, and others have too. This is so embedded in our economy and in our society. But this is part of what the responsibility to respect implies. Yet we've seen in the last 10 years of implementation that businesses really struggle with what we could think of as assessing contextual risk, right? The really understanding all the those elements, both institutional, so legal, but also social, of the context in which they're operating or sourcing from. And financial institutions have not really been asking them to assess contextual risk either. So we don't see that connection between what does a weak rule of law, what does an undermining of civic freedoms, what does undermining of democratic institutions, for example, and how this influences specific human rights risks. We don't see that being connected in human rights risk assessment. We see it in anti-bribery and corruption, but we're not really seeing it in the same way in human rights. And I take one specific example of trade union rights. So we focused a lot on this at Shift, and we've put out joint guidance with a Dutch trade union and global trade union allies on why these key enabling rights need to be foundational in due diligence and need to be prioritized for so many companies. Because undermining of trade union rights is a contextual risk in many countries. And no matter how many, well-intentioned worker empowerment programs you have, if you're not also using leverage to engage the government with your peer companies, with the ILO, if you're a multinational, for example, operating in that company, operating in that country, on recognition of trade union rights and on what that can enable, then you're probably not going to make substantial progress on living wage, on safe working conditions, on addressing pervasive harassment of women workers. So we would say that done right, and I think this accords with Michael's optimism, human rights due diligence expects attention to and understanding of systemic structural risk, but also a corresponding investment of leverage in trying to influence the contextual environment that connects to those risks.
Thanks, Rachel. And you've also written about how the Black Lives Matter movement goes to the heart of what the UNGPs are about. What are some of the lessons about how business needs to consider their connection to severe systemic impacts in an integrated rather than a reactive way?
Yes, as a US, Shift is a US headquartered nonprofit, and we really felt a particular responsibility to engage on this in the context where many of our team work, given the history of harm to Black communities from police and other forms of state sanctioned violence and continuing inequalities from the era of slavery. But of course, there are many connections with important differences to other contexts and impacts experienced elsewhere. Because what we saw, and I think Manel referred to this, is most business responses were framed as voluntary commitments by socially responsible, socially conscious companies, when what we saw from our business and human rights perspective was a responsibility to take action. And so we looked in some public guidance that we put out at the connections between companies' own operations and racial discrimination over the longer term. So starting specifically with things that I guess are more, easy to see, right? So the link between products and services and structural discrimination. So that in the Black Lives Matter context included things like companies that were providing goods directly to police forces, like IBM, without heightened due diligence. It also included the role of online platforms that were disseminating hate speech and companies that were advertising on online platforms, not taking any action in that regard. We saw that start to change. Included discriminatory access to financial services. That's a pervasive problem in the US market. And discriminatory portrayals in marketing. And here, we did see companies like Pepsi and Mars start to take some action about some of their brands. And we also saw that spill over a bit actually into the sports area, with sponsors starting to look at cultural appropriation of First Nations and other Indigenous names in the sporting team context. But sort of going beyond those more immediate connections, what we also saw the need for was that for companies to take a longer time period. I mean, we're talking about impacts that have been embedded for years, for generations. And so you need to set yourself clearer targets, and you need to take a longer time period, and you need to be willing to invest the resources that that's going to imply, and commit to transparency on progress. Again, we saw that starting to happen in some perhaps more predictable areas of the business, again, closer to home. So pay equity, as Bonita has said, incredibly important still. Procurement, the sort of broader climate in the organization around inclusion of racial minorities and other minorities, but also pushing business, and we didn't see much of this. Are your lobbying funds being spent to support elected officials with poor records on equality and policing issues? Are you considering the impacts of your taxation strategy, given the massive underfunding of public services for Black communities in the US? Are you using your voice to support specific regulatory reform that the Black Lives Matter policy platform was recommending? And I think our very strong feeling is that the responsibility to respect sets a floor, not a limit, on how companies can act and should act in support of human rights, and that there were rationales for them to speak out on broader Black Lives Matter goals and issues that went beyond the framework of the guiding principles. For the framework of the guiding principles to make sense and add value, you have to look for, is there a connection? What's the linkage? As I've just laid out, we actually think you can make a lot of connections. There are a lot of linkages that companies should be working on, but we recognize that there's more to do beyond that. And I suppose what we have said about that is that if companies are going beyond and wanting to use their voice on broader public goals, then they should still do that in consultation with affected stakeholders, with people who know the impacts, who are directly affected. And we see that as being particularly important in advocacy around LGBTQ rights. And my colleague, Daniel Berezowski from Shift, will be speaking about that tomorrow.
Thanks. And we're now going to turn to the law. There are currently various legislative movements underway, including towards mandatory human rights and environmental due diligence, a duty of care or a duty to prevent. And we've seen this at the European and national level. It's also something that we're talking about here in Australia. Krishnendu, do you have any thoughts about whether and how a law, and potentially a European law, could impact on the inequalities that you've described and the status quo?
Well, I think as people have said, there's not one solution to all of this. As we've been talking, many of these problems are ingrained, they're systematic. But what has to be recognized that even in situations where EU-based companies or American-based companies only a small part of the output or of these industries, proper and effective due diligence, looking at the entirety of cause and effect, working with communities, working with employees, and working with the wider general public, I think can have a significant effect on these situations. I'm absolutely convinced that they can do. And at the moment, what's important is to have case studies which can be upscaled or replicated in other places that show examples of good practice, so that the good practice can be followed by companies that have a real will, and obviously that's the crucial question: have a real will to implement these laws when they come into force.
Thanks. And Benita, you've been looking at the idea of positive obligations and positive duties. Many of the ongoing legislative movements towards mandatory human rights and environmental due diligence, and even proposals for a duty to prevent, would operate as a positive legal duty. Could you share some of your thoughts on positive obligations and what they could or should look like, particularly in the context of structural inequalities in the historical context?
I mean, the first point to make is that the whole distinction between positive and negative, of course, is an artificial one and often an unhelpful one in terms of rights, but I do think it is helpful in terms of duties and understanding the nature of the duty. And my premise, my proposition is that there is a lawful and politically justifiable basis for multinational corporations to have positive obligations to not only prevent violations, but also to fulfill human rights standards. And that is a very contentious concept, and I think unnecessarily so, for reasons I'll explain. I do think, though, that for multinationals emanating from the global north, particularly, or very wealthy multinationals operating in contexts of high levels of poverty and inequality, there becomes or there arises a positive duty to fulfill human rights, including socioeconomic rights. And this triggers a visceral reaction on the part of those opposed to the notion for many reasons. It appears to be an invasion of the autonomy of a corporation. It appears to be a ticket out for governments to actually take responsibility for those aspects of its society that are suffering as a result of inequality. But I think there's some very practical, reasonable, and arguably sustainable situations in which corporations may be held liable to fulfill human rights and to put money into that fulfillment. And I've posited elsewhere that there should be about 5 or 6 factors that I refer to and can discuss here. Some of them are around the seriousness of the violation, the imminence of the violation, and one of the aspects is this notion of a gatekeeper. And the gatekeeper is where a corporation is the only entity that is able to provide the fulfillment of that right, not forever, but for a limited period of time. The question becomes, is it lawful for them not to? Much of this is moored in the notion or in the history of the circumstance. And Freya and Rachel, you've both very evocatively referred to the historical context in which this discussion is taking place, and the fact that that historical harm is very present. And if we if we are truly responsive to law and not to ethics, not to morality, but to law, then if we take, for example, the situation in South Africa or in Australia, corporations operating on and benefiting from the fruits of land that was stolen owe that money back. So of course, the chain of causation is going to be raised as a reason not to have that obligation. But if one were to say, but that obligation doesn't arise merely because of your presence there, but the obligation arises where your presence there creates a situation in which you are the only one who can help, in which the most vulnerable are going to be hurt. And it's going to happen soon, and it's going to be egregious. And you hold the key to the fulfillment of that right. Why should we steer away from that? So I do think that positive duties are something that we should be bringing to the forefront without catastrophizing the notion of capitalism, of corporate autonomy, and the underlying principle, I think, is very interestingly reflected in the South African Constitution, which is one of the few, if only, constitutions in the world that is of a complete horizontal nature, in that the Bill of Rights will bind private persons, including juristic persons, in certain circumstances. Those situations are yet to be fully developed by the jurisprudence of our courts. But the principle is a resoundingly interesting one and a fascinating one, and in many ways is the leader others should follow, which is that there are reasonable circumstances where juristic persons will have the same duties as the state, and perhaps even beyond.
Thanks, Benita. I always love hearing about the South African context. It gives us so much food for thought. Let us turn now to access to remedy set out in Pillar 3 of the UNGPs and the principle of where there's a right, there is a remedy. If we're talking about systemic inequalities, there is not always an individual actor against whom a claim for discrimination could be made, as we have examples in employment equality legislation. So Manel, could you speak to us about access to remedy in this context and the role or potential role of strategic litigation in relation to business and systemic inequalities? What can we draw from the current developments in the litigation around the implementation of the UNGPs?
Sure, thanks, Freya. I will first answer the second question because that's the easiest one, I would say, in the way that what can we tell about, what strategic litigation tells us about the implementation of the UNGPs? As we know, they are not themselves binding source of law. And so while they can be invoked before the courts, they cannot be sanctioned as such. And so there is, however, a real progress to note on that front, because there are increasing references to the UN guiding principles, including court decisions. So that actually started from 2013 by the Ontario Superior Court of Justice, also by the High Court of South Africa in 2015, and later on by the Inter-American Court of Human Rights. But there is also this very interesting decision, and more recent, of the Hague District Court ordering Royal Dutch Shell to reduce their greenhouse emission by 45% by the end of 2030 relative to 2019 levels. And the court interestingly qualified the UNGPs as, I quote, authoritative and internationally endorsed soft law instruments, which set out the responsibilities of states and businesses in relation to human rights. And it was a very powerful decision because they considered that those kind of soft law instruments, businesses bared obligations out of these. And while this judgment has been appealed in July 2021, it's still an interesting one to consider when it comes to reasoning and to the implementation of the UNGPs and their operationalization, I would say. And now when it comes to stricto sensu systemic inequalities, there were interesting cases used and brought by trade unions and other civil society actors to promote equal pay, notably in 4 European countries, Switzerland, Germany, France, and Poland. But still, one has to keep in mind that strategic litigation itself is an avenue which still presents a number of obstacles related to systemic barriers to access to justice. And so it requires funding, knowledge, and information about the procedures in place, legal assistance, and even when all of that is gathered, then you have to confront the obstacles related to the procedure itself. So for instance, standards related to admissibilities. So that takes time, that requires money, and redress is not necessarily guaranteed. So for that, I would say it's a mixed kind of table that we can see here in terms of, with regard to strategic litigation and systemic inequalities.
Thank you. And Rachel, you are working on the role of state-based oversight bodies to enforce human rights due diligence-based regulation and emphasize that these should be complementary to judicial or civil remedies for victims of or rights holders. Is there a risk that structural inequalities are also present in the way European-based regulation is designed?
Thanks, Freya. Yes, I mean, I think there is a real risk, and we're seeing this happening already. in the legalization of due diligence, that it becomes classified as a first-tier supply chain problem. And that leads us, or rather it leaves us, in the land of audit, command and control, top-down, management of issues, terminating relationships, cleaning the supply chain, all the things that we're actually trying to move away from through the guiding principles and through true human rights due diligence. And so if that's what is meant for many European or Western headquartered companies by the concept, and that's what gets turned into law, then that's going to lead to predictably not just bad but distressing outcomes for affected communities and workers, in cocoa producing companies, in electronics factories in Malaysia and beyond. And we've already seen this tension, I think, with the use of the US import ban, that there's been great attention by some involved in that debate to make sure that workers actually are receiving remedy in the cases, or at least repayment of recruitment fees, which is what remedy is sort of translated to mean at the moment, in those situations where bans are imposed or withhold release orders are imposed. But that's a struggle because the customs mechanism itself was not designed for that purpose. It's designed for quite a different purpose. So we think that there is a real risk that European courts and administrative agencies make decisions that make sense in Brussels or wherever they are, but that don't take account of impacts and outcomes on the ground, and probably particularly so if administrative agencies are making many decisions at scale, reviewing large numbers of companies in new and sectors with challenging issues. So one of the things that we've been emphasizing is how they can collaborate and need to collaborate, whether it's with their own country's embassies on the ground, whether it's with ILO country offices, obviously taking account of existing social dialogue structures where they exist, requiring companies to integrate stakeholder perspectives into their proposed mitigation actions and requiring evidence of that. And we have to think about what evidence means, given all the concerns around audit. But there's lots that could be done, but it's got to be creative. And creative and sort of administrative supervision are maybe not concepts that go together naturally. But we're trying to push that conversation where we can, together with the Office of the High Commissioner for Human Rights. And I do think that we have an opportunity. We looked at this in some work we did called Signals of Seriousness, where we were highlighting some of the features of due diligence that make it unique, that bring the human element to the forefront, and really flagging them to say, these are the kinds of things that we think administrative supervisors will need to consider, will need to look for as evidence of whether a company is genuinely trying to make progress, as opposed to whether it is ticking the box on a series of process steps, which may look very nice on paper, but may remain disconnected to those outcomes on the ground, or indeed may lead to perverse incentives about how supply chain relationships are managed.
Thanks, Rachel. And Manel, following up on this, we're in a landscape where there's increased social awareness of systemic inequalities, including on social media, at the same time as a new wave of laws around corporate obligations are being designed. You've mentioned the question of who is having the seat at the table, and could you elaborate on this important point for us?
Sure. So I was mentioning how strategic litigation is one avenue to further corporate accountability when it comes to systemic inequalities, rather limited still. But there are also discussions on, having a business and human rights treaty binding, and all those discussions kind of take place at the institutional sphere, I would say, even though it comes with obviously a consultation process with a number of stakeholders. But as Krishnandu was mentioning, we need to have a broader range of stakeholders involved. And social media, in that sense, seems a very important bottom-up lever of accountability for businesses, and especially those that are widely receptive to those platforms because they're sensitive to their reputational risks. And so that brings me back to that campaign that was launched last year by Sharon Shooter, who is the founder and CEO of a cosmetic beauty brand. And she initiated this movement called Pull Up for Change and this viral hashtag Pull Up or Shut Up. And the idea of this campaign was in response to businesses expressing their commitments to diversity in the midst of the Black Lives Matter movement. She asked the brands to release within 72 hours the number of Black employees they have in their organizations at the corporate and executive level. And that campaign shed light on how some businesses rely heavily on Black culture for marketing purposes, but they actually have a very low number of Black or Latinx employees at the level of leadership. And another great illustration, again, through social media, that show how they can be real agents of change in that field, was the campaign 15% pledge that called on major retailers to distribute 15% of Black-owned businesses' products on their shelves. And major retailer joined the pledge and made that commitment last year. So those are initiatives that were born on social media and that were launched by business actors on the ground who may themselves face structural barriers to access to justice, investment, employment, and are not necessarily involved in those consultative and kind of more technical processes because of those structural barriers. And as a result, they don't necessarily have their voice heard on those platforms, but their initiatives should definitely be granted more attention. So that's how I see social media as a real lever for to address systemic inequalities.
Thanks. And Benita, you've also raised the issue in the context of financial institutions. There's been a recent example in South Africa relating to social grants and financial institutions, including the IFC. Could you speak to us about this example and the lessons that we could learn from this?
Thanks. In many ways, I think this example or sort of exemplifies the moving parts of this discussion. It involved the right to receive social welfare in South Africa is a constitutionally protected right. And the obligation to distribute the grants itself, the actual mechanisms, is one that was very difficult for government to implement for a whole range of reasons, not least of all because those who are the majority of grant recipients live in far-flung areas, often are unbanked, and are not able to access financial instruments. A company bid for a tender to distribute those grants. The company's name it's now dissolved, Cash Paymaster Services. It was the subsidiary of a Johannesburg listed and New York listed company, Net1. The CPS was granted this tender to actually distribute the grants, and it would do so through a really impressive banking platform. And it did it in a way that would allow the most indigent to access their grants through the cell phone, bearing in mind that everybody in South Africa has a cell phone or access to a cell phone. So it was deemed the most appropriate and the safest way of doing it. And it made a lot of sense. The problem was that tender was challenged by the other tenderers, and the Constitutional Court found that that tender was unlawful. But it actually continued to allow this company to continue distributing the grants because basically they had no other option. If this company didn't do it, nobody would, and nobody would receive their social grants. It was a bit of a crisis situation. Over the period of 5 years, which was the duration that the company was given to do this job, an alarming phenomenon happened. Grant recipients started to find that large chunks of money were missing from their grants at the beginning of every month. Sometimes the entire grant would be gone. And you can imagine for a person who has a child grant for their child, this is very serious. And obviously in South Africa, it's not just one person who lives on a grant. The grant helps families survive, as is the reality. And it turned out that CPS, as part of the Net1 group, had access to all of the data and biometrics of the grant recipients, and was busy had been transferring that data to other subsidiaries within the same corporate entity within the Net1 group that would then use that data to execute malevolent targeting of financial services to grant beneficiaries. And a lot of those financial services were sent in a manner that grant recipients either didn't understand or were sent in a way that would exploit grant recipients' indigent circumstances. The problem, though, was not so much that they were given these or offered these services. The problem was that if, for example, a person chose to have an emergency loan, the repayments would then be deducted directly off their social grant by CPS, which was both unlawful in certain respects and obviously widely unethical. Technically, there was a way in which the grant recipients could contact CPS to find a way out of this, but the contact number was free if you were phoning from a landline, but otherwise it would cost you. Now, there are no landlines in most of the areas where grant recipients live. So the reality is that there was no functional remedy. There was no functional relief, even though they claimed to have one. We actually spent 2-3 days trying to phone that line, and that there was no answer. But the complication of all of this was that money was coming off these accounts in such huge amounts that the IFC, International Finance Company, which was the largest shareholder of Net1 with a shareholding of over 16%, had reinvested in CPS after the Constitutional Court declared that it had a constitutionally invalid, unlawful tender, that decided to reinvest because they claimed it was demonstrating a really useful way of ensuring financial accessibility to people living in poverty. But the reality was they were making money hand over fist. So much so that towards the end of the period that CPS had this contract, the IFC, so I think it was about 2017, the IFC reported that in all of its African investments, the most lucrative was CPS. And so this is a development bank aimed at deconstructing poverty. And it made an untold, self-confessed fortune out of deductions from the poorest, marginalized, most destitute people who have never got their money back. Never. And when the Constitutional Court had to deal with this again, and we went back to the Constitutional Court to say this is happening, the court said, all right, you're not allowed to do it anymore. But the horse had bolted. And a few months later, about a year later, CPS declared bankruptcy. But the harm was done. And so you can talk about remedies and you can talk about these facilities. And actually, I sat down with representatives of the IFC who came to South Africa to find out what had gone wrong, because the press around this in South Africa at the time was significant. And they insisted they had done their due diligence. And my response was, every single person in the social justice sector in South Africa knew this was happening. There were reports going on about it. How could you honestly say you've done your due diligence where a simple Google search would have yielded the result? But as matters stand, the most indigent in this country have suffered so that the wealthiest in the world profited.
Thank you, Vanita, and what a poignant example for discussing this topic, and definitely a cautionary example of what we need to keep in mind as we develop systems to address these measures and take those inequalities into account. Krishnender, we've heard about the status quo and structural challenges inherent in the current system now from a number of our speakers. Is there a way to move forward in a practical way using the UNGPs, and all these experiences as tools towards equality and justice?
Yeah, thanks, Freya. I mean, I think the COVID crisis has really illustrated the massive systemic inequalities in the system. One couldn't have been, obviously moved to see the vast numbers of people walking back home in the Indian context, having lost their jobs and facing humanitarian crises. And climate change is already similarly affecting the most vulnerable and marginalized. And it's hard sometimes not to feel despondent, but I mean, two of the things that we should take away and not feel despondent about is firstly that in terms of business, the language of human rights and environmental rights wasn't in the language of business until a decade or so ago, and that's a huge step forward. And even though when we talk about modern slavery, we understand that modern slavery is about gross violations, and yet there are much wider labor violations going on. The term modern slavery allows us to conceptualize the most grossest of human rights violations that are happening to labor. So those are two positive things that are happening. I mean, I think those positive things have to be built on. So there has to be an adoption of the language of human rights and the adoption of the principles and the working mechanisms of the UNGPs by states and by corporations. And they do have to participate in these into these mechanisms, which I talked about earlier. But I'm absolutely with Rachel in terms of bottom up. I think that we have to start from the bottom. We need to see what's affecting communities and labour, and we have to use that to ultimately to set the standards and to enforce those standards in the context of human rights due diligence and tackling systemic inequalities.
Thanks, Krishnendu. And we do have time for a couple of questions. So if you do have questions, please do feel free to put them in the Q&A. But one of the questions that we've received is from Sandhya Drew. The question is, should due diligence address the structural inequality which is revealed by wage inequality, minimums and maximums? And if so, what mechanisms do the panel suggest beyond living wage guarantees in supply contracts? And I might direct this one to you, Rachel.
Thanks, Freya. It's a great question. The short answer is yes. The answer to the first question. The answer to the second question, there's a couple of parts. The first thing I would say is, again, fundamental in human rights due diligence is don't offload your human rights risks. So putting it in a contract is great, but if your purchasing decisions do not take account of the real cost of labor and you're not having that conversation upfront in whatever specific context it is you're sourcing from, then you're not really yet meeting the responsibility to respect if you just offload that risk to the supplier and seek to maintain the same terms. The second thing I would say is, and this is the slightly nerdy answer, reporting and accounting standards, they matter and they need to be changed. So accounting standards actually consider wages as a cost to the business, right? Pure and simple. They say, they don't recognize the potential human and social capital that's inherent in the idea of wages and the value that they bring to the business. So we have a project at the moment at Shift looking with accounting and trade union and reporting experts at how to develop an accounting model for the living wage that would enable companies, many of them are now starting to make, a few leaders are starting to make declarations about commitment to living wage, but they can't show it. And so they can't be tested on it, but they also can't get credit for it. And it doesn't necessarily incentivize anyone else. So we need a way to show this in accounting terms and value it in accounting terms. So that's a way in which we're trying to make a contribution to that really important fight.
Thanks, Rachel. And Benita, do you also have some thoughts on this one?
very esoteric ones, unlike the very effective and concrete and practical response from Rachel. But I did a training recently for a multinational mining company. They do a leadership training, and I was speaking about some of the human rights and environmental responsibilities that leaders may want to consider. And I spoke a lot about this, the question of remuneration. And it's almost, one wants to move away from the language of wage. It's proper remuneration, because it's not just about how much money you're given. It's about whether you are given access to healthcare, right? And all of those aspects that come with the package that those sitting in senior officers receive. It's not the quantum at the end of the day, it's the entire package. But we are speaking about notions of remuneration. And Rachel, you said there's a nerd in you. Oh my, I can out-nerd you any day. The philosopher John Rawls developed this concept of the veil of ignorance, right? Many of you may know about it, where you think about a just society behind a theoretical, hypothetical veil, right? And you can't see what that society is going to look like. So from behind that veil, you have to create structures within the society, and you don't know where in that society you'll sit. You don't know if you'll be able-bodied or not. You don't know if you will be have a specific gender identity, whether you'll be binary, whether you don't know if you'll be rich or poor. You don't know where you'll sit. And the idea is that if you don't know where you'll be placed in society, well, then you will be very careful as to how you calibrate justice and economic equality in that situation. And so the challenge I posed was, if you don't know where you're going to sit in the mining industry, how would you ensure value-linked remuneration? And I think that's the question, right? Because you don't know if you're going to be occupying a position of a cleaner or an underground worker or the in-mine manager or the financier or whatever the case may be, the leader. And you've got to justify the reasons for it. And that, I think, is quite a useful tool to actually really sincerely ask and escape assumptions about what valuable work looks like. One of the reasons, or one of the explanations I often get from people who talk about the justification for such a large gap between the highest and lowest paid people within the mining industry, or with any of these industries for that matter, with any major industry, tech industry, financial services industry, is because those who lead it have very rare skills. And those who lead it are very few, and those who lead these sectors have rare education. But I always query that as a valid justification, because how many of those leaders fail regularly to actually lead those sectors responsibly? But then also, the scarcity of skills is something that actually applies at many levels of industrial operations and marketplace work. So if we then have to take scarcity of skills off the table, what's left? Well, maybe education. But formal education is only one type of education. What about the inherited knowledge about a mining mechanism, or inherited knowledge about the growth of a product, agriculture, the manufacture, the creation, whatever it is? Why do we devalue that, right? And why is that lifelong intergenerational knowledge worth less than a degree obtained from a shabby university like Harvard or Yale or Oxford or Cambridge, the case may be? So I think the veil of ignorance is a cheeky but potentially useful and very nerdy approach that could be taken.
Thanks, Denise and Rachel, and I think that that's a fabulous place to wrap up this morning's discussion. Thank you very much to all the panelists for your fantastic contributions, and I hope everyone enjoyed it as much as I did. Now, there's a reminder that the next session will be starting at 2 p.m. UK time, which is on human rights due diligence and systemic inequalities, and it can be accessed through the same link. So enjoy your lunch, and hopefully you can join us at 2 p.m. Thanks, everybody.